If you are a United States citizen, a green card holder, or someone with a pending immigration case, and especially if you are 65 years of age or older, I need you to stay with me for the next few minutes. Not because something terrible is about to happen, but because a lot of people online right now are talking in a way that's creating unnecessary fear. And when fear mixes with immigration topics, especially for seniors, it can feel overwhelming very quickly. Over the past few days, many of you have seen headlines or social media posts talking about new citizenship rules, seniors being affected, accommodations changing, or even scary words like denaturalization being mentioned without explanation. Some of you messaged me saying your heart started racing. Others said you couldn't sleep. Some of you quietly wondered after all these years, is my status still safe? Let me say this clearly at the very beginning so we set the right foundation. There has been no sudden rule that strips seniors of citizenship. There has been no mass change targeting older immigrants. There has been no announcement that people over a certain age are now at risk simply because of their age. What has happened is far less dramatic and far more procedural, but the way it has been talked about online has distorted the reality. In this video, I'm going to do three things very calmly and very clearly. First, I'm going to explain what actually changed and what did not. Second, I'm going to explain who these updates apply to and, just as importantly, who they do not apply to at all. And third, I'm going to walk you through what seniors and long-term residents should realistically do right now, so you feel grounded and prepared instead of anxious. This is not about rushing you. This is not about pressuring you. This is about clarity, because fear grows in the absence of understanding, and immigration systems are already complex enough without misinformation filling the gaps. Before we go any further, I want to talk briefly about why immigration news hits seniors so differently. Immigration headlines don't feel like ordinary news. They don't feel abstract. They feel personal. They touch identity, home, family, and the future. If you are over 65, you have likely spent decades building a life here. You worked, you paid taxes, you raised children, you supported communities, you followed the rules, even when they were confusing or slow. So, when you hear words like rule change or citizenship update, your mind doesn't think about paperwork. It jumps straight to worst-case scenarios. That reaction is not weakness, it is human, and social media makes it worse. Online platforms reward urgency, not accuracy. A headline that says, "New senior citizenship rule gets clicks." A headline that says, "Internal procedural clarification about documentation consistency," does not. Fear spreads faster than facts, and suddenly it feels like something massive changed overnight, even when legally it didn't. That is why I want you to hear this clearly. Feeling fear does not mean you are in danger. It means you care, but fear alone is not a reliable source of information. Facts are. So let's replace fear with facts. Now, let's talk about what actually changed. Over the past weeks, immigration authorities issued clarifications about how certain parts of the naturalization process are handled, particularly when it comes to verifying eligibility for existing senior accommodations. These accommodations have existed for many years. They recognize that age can affect memory, language learning, and test-taking ability. That recognition has not been removed. It has not been quietly taken away. What has been updated is how officers are instructed to verify that an applicant qualifies for those accommodations. That means closer attention to documentation that shows a person's date of birth and the length of time they have held lawful, permanent resident status. These requirements were always there. What changed is the emphasis on consistent review and clear documentation. This is about procedure, not permission. It is about consistency, not restriction. Unfortunately, when this kind of update is summarized online, it is often described as a new rule without context. And when age is mentioned alongside the word rule, fear naturally follows. But a procedural clarification does not mean the government suddenly decided seniors are unwelcome or unqualified. It means officers are being reminded to apply existing rules carefully and document their decisions properly. Now, this next part is extremely important, so please listen closely. If you are already a United States citizen, Whether you were born here or you became a citizen years ago through naturalization, these updates do not change your status. They do not reopen your case. They do not undo your oath. They do not place you under review simply because you are over a certain age. Citizenship once granted is not casually revisited. Procedural updates to how new applications are reviewed do not retroactively affect people who already completed the process. I want to say that again in very plain language. If you are already a citizen, nothing announced recently takes that away from you. Your status is secure. A lot of fear among seniors comes from not knowing whether a change applies to the past or only to current and future applicants. In this case, it applies only to people who are actively going through the naturalization process or planning to apply. And even for them, this is not about creating new barriers. It is about making sure the correct rules are applied to the correct people. Now, let's talk specifically about seniors who are applying for citizenship or planning to apply. For many years, the immigration system has included accommodations for older applicants. If you are 65 or older and have been a lawful permanent resident for at least 20 years, you may qualify for a simplified civics test. And in many cases, the ability to take the test in your native language with an interpreter. These accommodations are still available. They have not been eliminated. What the recent updates emphasize is that officers should clearly verify eligibility for these accommodations. That means making sure dates and documents align. Officers may ask more direct questions. They may look more closely at green card history or dates of residence. This does not mean suspicion. It means structure. When your documents are organized and consistent, this often works in your favor. Confusion arises when people hear closer review and assume it means more denials. That assumption is not supported by the actual guidance. Another fear I want to address directly is the idea that making a small mistake on an application could now lead to serious consequences. This fear has caused many seniors to feel paralyzed, afraid to apply, afraid to move forward. Here is the truth. The immigration system has always distinguished between innocent mistakes and intentional fraud. A typo, a forgotten address, or an incorrect date written accidentally is not the same as lying to obtain benefits. In most cases, minor errors can be corrected. Officers may ask for clarification or additional documents. That is a normal part of the process. Intentional fraud is different. That standard has existed for decades and applies to everyone, not just seniors. Confusing these two things is what fuels unnecessary panic. Now, I want to talk about a word that has quietly scared many people, even when it is not fully explained. That word is denaturalization. When people hear this word, it can sound as if citizenship is fragile or temporary. But that is not how it works. Denaturalization is an extremely rare legal process. It is not administrative, it is not automatic. It requires the government to prove in court that a person intentionally committed serious fraud during the naturalization process or concealed extreme facts such as involvement in war crimes or terrorism. It involves judges, evidence, and the opportunity to defend oneself. It does not happen because of small mistakes, misunderstandings, or policy updates, and it does not happen quietly. Procedural updates to how current applications are reviewed do not create new pathways for denaturalization. Adjusting how officers verify documents today does not retroactively change the standards applied to people who became citizens years ago. The legal threshold remains extremely high, and nothing announced recently has lowered it. If this topic has been weighing on you, pause with me for a moment. Take a slow breath in, hold it briefly, and then let it out slowly. Fear tightens the chest and speeds up the mind. But fear is not the same as danger. Understanding the difference gives you power. Immigration is not just legal. It is emotional. It touches belonging, safety, and identity. When those things feel threatened, even indirectly, stress can build quietly, but knowledge restores balance. Now let's talk about what you can do because action replaces helplessness. First, organization. Keep your important documents together: green card, passport, naturalization certificate if you have one, copies of applications, notices. When documents are organized, questions feel manageable instead of overwhelming. Second, Keep your address updated. Missing a notice because of an outdated address creates stress that has nothing to do with eligibility and everything to do with communication. Updating your address is simple, but it protects you. Third, if you have an upcoming interview or test, preparation does not mean fear. Review the civics questions that apply to your situation. Understand what documents you need. Arrive calmly and on time. Officers follow structured processes. They are not there to trap you. If your case involves complex issues, professional guidance can help. Consulting an immigration attorney or nonprofit organization is not a sign that something is wrong. It's proactive. Waiting is another source of anxiety. Processing delays are common. Silence does not mean rejection. If your case is within normal processing times, patience is often required. If it is far outside normal times, there are official ways to inquire without harming your case. Travel is another area that causes worry. Lawful permanent residents can generally travel, but long absences matter. Planning ahead protects your status. Again, this is not panic. It is preparation. I want to speak directly to seniors now. Many of you have spent decades contributing to this country. Your presence here is not fragile. Your rights are not invisible. The accommodations that exist for seniors exist because the system recognizes human reality, not because it is doing anyone a favor. The path to citizenship remains open, and if you are already a citizen, your place here is not being questioned because of your age. So, let's bring everything together. The recent updates involve procedural clarification, not new restrictions. Senior accommodations remain in place. Citizens are not affected. Denaturalization remains extremely rare and court-based. Mistakes are not the same as fraud. Delays are common. Fear is understandable, but panic is unnecessary. If this explanation helped you feel calmer or clearer, consider sharing it with someone who may be anxious right now. Staying informed with accurate information is one of the most powerful forms of self-protection. You are not alone in this journey. Stay grounded, stay informed, and take care of yourself and the people you love.